the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure.
Hey everyone, welcome back to the channel. Today we're diving into a fascinating exchange between Senator Kennedy and a judicial nominee about how judges interpret laws and the Constitution. Trust me, this one's packed with insight on how legal minds actually approach legislative history versus the text of the law. Before we get into it, make sure you smash that subscribe button so you don't miss future breakdowns like this one.
Senator Kennedy's the next. Senator Kennedy, you're the next one.
Thank you, Mr. Chairman. Counselor, as you know, it's hard to pass a bill in the United States Senate. Our founders intended that to be the case. And consequently, if a bill does pass, it's gone through a long, arduous process. A lot of reports issued, a lot of debate, and all of it's written down. Why has it become common practice, and do you support it, of ignoring that rich legislative history when you interpret a statute?
Well, Senator, I think the first rule of statutory interpretation is that the text is what's paramount. And that's because the text is what actually proceeded through bicameralism and presentment, which are really just the fancy.
Of course, it's paramount, but why can't the text be supplemented by looking at the history?
I think the legislative history can sometimes provide a tool to help interpret the text. And it's often in parties' briefs, and I would, of course, consider it that way. But it's just important to keep in mind its subordinated role in that interpretation, because the intention of any particular legislator does not have the force of law. Instead, the text does. So the legislative history and the intentions of specific legislators should never take primacy over the text or refute the text.
But it doesn't have to, does it, Counselor? It just gives you context.
I agree with that.
When you interpret a statute or write a brief, and you think that the language is plain, aren't you tempted to go look at the history just to make sure that your interpretation is correct?
It depends, I suppose, on the particular statute and the nature of the history at issue and the question.
But don't you want to just go take a peek? You look at the language and you say, well, this is as clear as thunder on a summer night. But maybe I'll just take a peek at the legislative history to make sure that I'm not out in left field. And the Supreme Court condemns that, does it not?
The Supreme Court does not uniformly condemn that, and there are certainly cases where, legislative history or statutory history has provided a tool.
Sure they do. I mean, originalism, and I'm not saying they're wrong. Please don't misunderstand me. I'm just trying to understand your perspective. Originalism and textualism is accepted even by the left of center justices. And I've read opinion after opinion, lower courts as well, where they say, well, legislative history, we can't rely on it.
Legislative history cannot be relied upon to trump the language of a statute. And so when the language of a statute really is that clear, Senator, there's not that much, and it bears directly on the question before the court.
Well, let me ask you something. Does the Supreme Court sanction looking to the Federalist Papers and interpreting the Constitution?
Yes.
Why isn't that legislative history?
The process for ratifying the Constitution is, of course, different than the bicameralism and presentment process that applies to statutory text. The Constitution was, of course, publicly ratified.
No, it's not.
Well,
you look at the plain language, don't you?
Yes. But in looking at the plain language, the question we ask is, what was the original public meaning of that language?
So Senator Kennedy kicked things off by asking why courts often ignore legislative history when interpreting statutes. The nominee responded with a simple but powerful point. The text itself is paramount. Why? because the text is the only thing that actually goes through the full legislative process: debate, amendments, passage, and signature. Now here's where it gets interesting. The nominee didn't completely dismiss legislative history. They admitted it can be useful as context, but emphasized it should never override the statutory text. After all, the personal intentions of individual legislators don't carry the force of law. Kennedy wasn't fully convinced and pressed harder, asking if judges at least get tempted to take a peek at that history, even when the text seems crystal clear. The nominee pointed out that it really depends on the statute, but yes, sometimes the Supreme Court does allow limited use of legislative history. Both agreed, though, that legislative history cannot and should not trump clear statutory language. That's a big deal because it shows there's a balance. Context is allowed, but the text rules above all else. Kennedy then raised a powerful question. If legislative history is unreliable, why do we rely so heavily on the Federalist Papers when interpreting the Constitution? The nominee's answer drew a sharp distinction. Unlike ordinary statutes, the Constitution was ratified through public debate. Documents like the Federalist and Anti-Federalist Papers actually reflect the original public meaning of the text. That makes them far more legitimate for constitutional interpretation than a single legislator's floor statement on a bill. Finally, Kennedy asked, if this all boils down to history, why not let historians interpret the Constitution? The nominee pushed back, explaining that judges are best suited because they don't just read history, they apply legal reasoning to connect past debates to modern legal challenges. In their view, it's a uniquely lawyerly task that blends history with law. So, to sum it all up, the text of the law always comes first, legislative history plays a supporting role at best, and when it comes to the Constitution, those founding-era debates are key to understanding original meaning. What do you think? Should judges rely more on history or stick strictly to the text? Drop your thoughts in the comments below. And hey, if you found this breakdown helpful, don't forget to hit that like button, subscribe to the channel, and turn on notifications so you never miss another deep dive. Thanks for watching, and I'll catch you in the next one.